Thank you, Mr. Chairman. Today's hearing is on two Republican-sponsored bills. While both bills pertain to local issues in the sponsors' districts, they also speak to broader policy issues on our public lands and merit careful consideration by this committee. Our nation's public lands belong to all Americans and support a wide range of activities. As such, the decisions we make about their management must reflect this broad constituency and mandate, and our hearing today gives us that opportunity. H.R. 1815, sponsored by our colleague on this subcommittee, Representative Hardy from Nevada, amends the Lincoln County Land Act of 2000 and the Lincoln County Conservation Recreation Act of 2004, which together authorized the sale of over 100,000 acres of federal lands in Lincoln County, Nevada. Proceeds from the sales are to be divided between Lincoln County, the state of Nevada, and a special account held by the U.S. Treasury designed to fund key conservation and development priorities, such as archaeological resource protection, wildlife habitat preservation, and the acquisition of environmentally sensitive lands. This reflects Congress's intent to simultaneously promote economic development and encourage environmental stewardship. To date, over $50 million have been put into the special account for the benefit of Lincoln County and its residents. The legislation before us today expands the use of these special funds to also include forest restoration and hazardous fuels reduction projects, which make landscapes more resilient and less susceptible to catastrophic wildfire. We are all acutely aware of the need to accelerate the pace of restoration projects across our public lands in order to decrease the risk of catastrophic wildfire. Over 11 million acres of land have been affected by wildfire so far this year, making 2015 one of the worst wildfire seasons on record, and this is a trend that is expected to continue. Both the Forest Service and the U.S. National Climate Assessment predict that the frequency and intensity of wildfires will increase throughout the 21st century, largely due to the effects of climate change. Adequately funding wildfire resiliency projects is a national priority, and I understand Lincoln County's desire to increase the amount of funding available for such projects in their community. I do have concerns that this legislation is shifting funds meant for conservation, preservation, and development to fuels reduction and restoration projects. But I look forward to hearing more from the bill's sponsor on why he thinks this legislation is the best path forward. The second bill we are considering today, H.R. 3342, sponsored by Dr. Fleming of Louisiana, attempts to resolve a surveying issue in his district. This bill would nullify the results of a 1967 survey which found that 200 acres of land in the Bossier-Levy district in northern Louisiana belongs to the federal government. The results of that survey were largely ignored until recently, and the approximately 50 homeowners in the affected area are just now learning that they do not hold legal title to their property. It is my understanding that BLM is currently working with landowners to verify ownership claims under the agency's existing administrative authority. I look forward to hearing more about how H.R. 3342 will impact that process. While we may debate some of the details of these particular bills, I am encouraged that this committee is considering legislation driven by local concerns. There are many bills assigned to this subcommittee sponsored by Democrats that have the same level of local support and interest, and I look forward to working with the majority to schedule hearings on those bills sometime in the near future as well. With that, Mr. Chairman, I yield back the remainder of my time. Dr. Fleming, you commented that in, I think you said September of 2013 was when this issue came to the fore again. What prompted it?
My recollection, it had to do with some mineral rights questions came up. A large company wanted to, I think, lease some land for the purpose of exploring for oil or gas. And they began to do an extensive title search, and they came upon this cloud. And so in trying to resolve the issue so that the landowner could lease the land, this created notice to everyone in the area that there was a potential cloud on everybody's title.
And that answer actually raises another, in an earlier life I was a lawyer, and I know that I did some real estate transactions in which, as we did that, we would always go to the registry to sort of see what what the title issues were. Why this issue did not, if it showed up in 2013, why it did not show up in other transfers of title over the course of time since 1967.
Right. I'm not a lawyer and I've never researched a title, but my understanding on this, Ms. Tsongas, is that from the state's perspective and through the state records, the title was clear. Remember that the state then and even now, and I have a letter, by the way, from the Attorney General that I would like to submit for the record, and also 3 landowners as well. But from a state's perspective, and a lawyer who is practicing under a state license, unless that lawyer went to the Federal Registry, would not have known and would have given clear title.
So the entity that was interested in, that was prompted in 2013 by its interest in some of the mineral rights, they did not find that in the registry? They found it through the Federal Register, or were they able, do you know?
Offhand, I'm sorry, I really don't know the answer to that. I just think that to give you a little bit of context for this, in Louisiana, but because of our unique laws that we have, they're the so-called Neapolitan laws, you know, the old French laws. Large companies that come in to explore minerals try to be very careful because they don't want to get caught in some of the issues that are unique to Louisiana. So I think they probably went further than a typical lawyer would go in exploring these topics, because it's one thing to talk about a $50,000 piece of property. It's another thing when you may have millions of dollars of minerals and they want to get it right the first time. So that's just giving you context. I'm not saying that's actually what happened, because I really don't know.
Okay, thank you. Thank you. I yield back. Thank you, Mr. Chairman, and thank you, Mr. Ellis, for being here. I wanted to follow up on some of the questions around the legislation before us that affects homeowners in Louisiana, and I certainly appreciate Dr. Fleming's strong advocacy for his constituents. But the reality is, as he said, that number one, what prompted all this was in September 2013, the sort of discovery of minerals and the interests of somebody in going forward and seeing what their title would look like if they wanted to move forward with developing those minerals. So that's number one, and I'm gathered that from that, the broader neighborhood has become aware of the cloud on their title. And I think we're all obviously sympathetic to those landowners, but I also know that this committee has a responsibility to balance the interests of the local community with the rights of all Americans, because federal lands, our public lands, are the inheritance of all Americans, and we have to be sure that we do right by those as we move forward. It's not always easy, obviously, as today's hearing is a testament to. So I just wanted to ask you that this legislation would nullify the BLM survey, and why is it important that you retain your survey authority, and what kind of precedent would this set were it to be nullified?
All right, Congresswoman, thank you for the question. The Public Land Ordinance back long before I started my career, 1785, established authority for public land surveys and transfer to the public domain. And so back, as I understand it, back in 1838, the General Land Office conducted an original subdivision survey of this area. It's also my understanding that at that time they followed a meander line rather than what was historically what we refer to as the original high water mark that existed at statehood, and I think the 148.6-foot contour is what we have. So that meander line, 38 was on the survey plat. Well, the Bureau subsequently received a color title application that was back in 1967 for lands located outside that original 1938 survey line in Section 30. So essentially between the high water, the mark of the where the lake is today, and where that meander line was put in 1838. And that's what, of course, got the BLM looking at this, taking a look at the survey. So they went in there and did a resurvey of that area, which is not uncommon for the Bureau to do these resurveys. And based on that resurvey that was approved in '69, they found, lo and behold, there's 230 acres difference. And so that is really what made the situation that we have today. And so it's the difference of that 230 acre chunk.
So what kind of precedent does it set to nullify a survey? Does it set a precedent in other areas of the country that concern you? What are your concerns there?
Well, we are really the survey of record in the United States. You know, our cadastral survey, and it would set a precedent that would be very concerning to us all over the country. Really, even for other color titles that we've done. For example, in the state of Idaho, where I came from, where we worked one of these up in the Wood River Valley. It would, it would certainly, our concern would be affect all these surveys that we do all over the country.
And what kind of notice are you, one of the issues we've been hearing about is the only notice given was in the Federal Register. Is there any requirement that these things be recorded so as people are doing title searches as part of land conveyances, they become aware of these issues?
Well, there is, and it does have to be recorded, and in the Federal Register, but we do other things too. You know,
But there's no requirement that it be recorded locally. So, for example, if a homeowner is going, Louisiana may have sort of a different way of doing things. But I know in Massachusetts that you would go to research a title and any kind of claim on it you would become aware of. You don't have that requirement as part of these surveys?
Well, if I look at this particular situation, and I did ask the staff, you know, for a list of the notifications that they did in this particular case, and I'd be happy to provide those for the record. But they did file the official Federal Register notice in '69. Also, they filed it with the Louisiana State Land Office, June 27, '69. Civil engineers in Shreveport in '69. The local press, local paper, the New Orleans General Land Office, and also some of the recorder of deeds in the parish, and at least one member of Congress who made inquiries. So, and a few in the claimant. So
that suggests, actually, to me, it suggests that maybe the translation wasn't made to the local authorities where they may have received the notice, but it wasn't filed where those who are doing land title searches would have seen it. And that BLM obviously followed through and did what it felt was appropriate, but for some reason it wasn't recorded in a way that anybody seeking out and looking at title would discover it in the normal course of any conveyance.
Yeah. Based on what the staff provided me, they did follow the requirements that we had for filing these things. When we do these surveys, and again, if I look at the state of Idaho, where I came from before I came in this job, and our cadastral surveyors go out, and they're along these property lines. They talk to landowners, so they normally, if they're going to be on or adjacent to their property, they notify them when they do this.
Thank you. My time is up.